My name is Khalida binti Khairuddin and my matric number is 2021849048.
My name is Wan Isna Shahza binti Wan Isaruddin. My matric number is 2021460028.
My name is Adam Danish Mukri bin Jana Zamri. My matric number is 2021827954.
Assalamualaikum. My name is Muhammad Azwan bin Azali. My matric number 20218196. In this report, I will explain the court decision.
Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Imam bin Zakaria. My matric number is 2021204698. I'm the leader for the group, and in this video, we will explain about court case HOE versus Persatuan Penduduk DVILLA Equestrian. Okay, this case start when appellant do not want to pay a monthly maintenance and the respondent start his defense. The agreement that has in residential area is those residents who did not pay the monthly fee for security and maintenance charge would not have to open the boom gate themselves without assistant or security guard on duty. In this case, appellant consider this agreement is a troublesome matter. The government act that involved in this case is a Local Government Act 1976 LGA, Drainage and Building Act 1976 SDBA, and Country Planning Act 1976 TCPA. Okay, parties that involved in this case: first, appellant, HOE and his wife. Second, respondent was a resident association area of the housing estate, and the other party that involved in this case is Majlis Bandar Raya Petaling Jaya MBPJ.
Fake of the case. The appellant seems to be a member of the RE sometime in August 2010 and had since then stopped paying the maintenance and security charge. On 25 October 2011, the respondent issued a circular signed by the chairman, the treasurer, and the secretary of the RE notifying the residents that those who have not paid the security and maintenance charge will have to do a self-service entrance to the housing estate at 210 Malayan Law Journal 2054 MLJ is to say that they will have to open the boom gates themselves without the assistance of the security guard on duty. They dissatisfied with the above circular, the appellant lodged a police report date 30 October 2011. The appellant also lodged an online complaint date 31 October 2011 through the local authority Majlis Bandar Raya Petaling Jaya MBPJ website. The appellant discovered that the respondent's application to MBPJ for setting up of the alleged obstructions, the boom gates and the guardhouse was met retrospectively. MBPJ had approved that the alleged obstruction in a meeting on or about 22 December 2011, and this was confirmed by way of a letter date 11th January 2012. Of the 140 residents, 130 have agreed to the guarded community scheme by the RA. Only the appellant has objected, but only insofar that they should not be inconvenienced by the scheme. The appellant comments the action against the respondent on the grounds of inter alia nuisance and that the alleged obstructions were illegal structures that amount to obstructions in law. Additionally, the appellant sought and ordered that the alleged obstructions be demolished. The respondent counterclaimed for areas of security and maintenance charge and also for an injunction restraining the appellant from harassing the respondent and the security guards at the guardhouse.
In this court case, the plaintiff KEAN filed a claim against the Persatuan Penduduk DVILLA Equestrian for nuisance and obstructions. It was the appellant's case that the two boom gates and guardhouse guarding the entrance and exit to the housing estate were constructed on a public road, contrary to the rules and regulations of the local council and constituted and obstructions. KEAN said that he is having to open the boom gate himself without the assistance of the security guard on duty and picking up his visitors at the guardhouse. The plaintiff argued that the presence of the boom gate and guardhouse interfered with his right to enjoy freedom of access to and from his housing estates.
The defendant in this law case was the Resident Association of Housing Estate of Persatuan Penduduk DVILLA Equestrian, who decided that those residents who did not pay the monthly fee for security and maintenance charge will have to open the boom gate themselves without the assistance of the security guard on duty.
After the court listened all the argument from the appellants, the Court of Appeal affirmed the choice of the tribunal and dismissed the appellant appeal. After the court considering all the argument from the appellant in detail to defy the decision of the trial judge, the trial judge acknowledged that although the appellant had been caused a trouble, he was not obstructed from entering his property. The court held to dismissing appeal with cause, and the trial judges is reminded and verified.
Okay, in conclusion, private nuisance is a problem which everyone should take it serious. This is because it can lead to destruction of the harmonious situation in the society. Most of the private nuisance cases happen between neighbors, report to have a bad ending. Therefore, the individual should take a responsibility to avoid a private nuisance. Sometimes some people does not realize that they are doing a private nuisance. So, we as a responsible person who care need to educate and give them some advice before proceed to take a legal action. We tend to see a legal action as the right way to prevent a private nuisance, but sometimes the situation can basically be solved by communication between both parties. Lastly, I want to say that everyone should spread an awareness about private nuisance to avoid it happen in our community.